Well, good morning, everyone. My name is Jeffrey Salant. I am the HOA Information Officer for the Division of Real Estate, which is a division of the Colorado Department of Regulatory Agencies, also known as DORA. This morning, we are going to talk about the Colorado Common Interest Ownership Act, also known by its initials, CCIOA or Kiowa. Specifically, we will discuss the sections regarding unreasonable restrictions and prohibitions contrary to public policy. This will include discussion of unreasonable restrictions on energy efficient measures, electric vehicle charging systems, prohibitions contrary to public policy, such as restrictions on patriotic, political, or religious expressions, restrictions on emergency vehicles and certain fire prevention methods, restrictions on renewable energy generation devices, restrictions regarding affordable housing and certain drought prevention measures, as well as a discussion on restrictions regarding child care providers in HOAs. There are two handouts attached to this webinar, a PDF copy of this presentation, and a copy of the Colorado Common Interest Ownership Act. You may download these handouts at any time during this presentation by clicking on the blue links that are located under the Handouts tab on the GoToWebinar control panel. And if you are unfamiliar, this is what the GoToWebinar control panel looks like. The highlighted sections show you where you may access the links to today's handouts. If you have any trouble accessing the handouts, you're welcome to contact me after the webinar for copies. I'll be giving out my contact information at the end. But also keep in mind that this webinar is being recorded and it will be uploaded to the division's YouTube channel. And I will provide you with that address at the end. And the links to these webinars or to these handouts will also be in the description section of those videos. Please note that the information provided during this presentation is educational only and is not meant to provide or be construed as legal advice. Any legal questions should be directed to your attorney. And before we get into the presentation topics, I would like to take a moment to talk with you about my office, the HOA Information and Resource Center. The HOA office is a statutorily created office, and my position, the HOA Information Officer, is appointed by the Director of the Division of Real Estate. Per statute, the HOA Center provides information to homeowners regarding their basic rights and responsibilities under the Colorado Common Interest Ownership Act. It gathers, analyzes, and reports information that we receive through complaints and HOA registrations, and we write an annual report to the legislature based on that information. We create resource materials, provide education, and present forums such as this one. We maintain a website with information for the public with a terrific frequently asked questions page. And of course, we register HOAs. As for what my office does not do, the HOA office is not a regulatory program. We do not mediate or arbitrate. We cannot provide legal advice. We do not act as an advocate. We cannot assess fines or penalties. And finally, we are unable to enforce an HOA's failure to register. So moving on to today's topics, the first section of Kiowa we are going to talk about today is section 38-33.3-106.5. This section contains protections for homeowners regarding several different areas of concern. Political, patriotic, or religious expression refers to the display of flags, political signs, and religious symbols. We'll talk about what an association may and may not prohibit. The parking of emergency vehicles refers to an exception to prohibitions of commercial vehicles in an association and what specific rules a homeowner and an association must follow under those circumstances. We'll discuss certain methods of fire prevention, such as the creation of defensible space and what an association's obligations are in relation to that act. We'll discuss a little bit about renewable energy generation devices and how they're defined. We'll talk about limitations on the prohibition of affordable and workforce housing, as well as a homeowner's right to engage in certain drought prevention measures. And then finally, we'll talk about child care providers in HOAs. So the homeowner protections in Kiowa regarding flags have actually recently been amended to provide objectively even greater protections than before. Previously, associations only needed to allow homeowners to display the American flag and service flags such as the Blue Star and Gold Star flags. Currently, an association is not allowed to prohibit or substantively regulate any flag displayed by a homeowner in an HOA. This means that you may display nearly any flag you'd like on your own property, including in a window or on a balcony if it adjoins your unit. And although an association is allowed to adopt reasonable, content neutral, that's the key there, content neutral rules with respect to the number, location, and size of flags and flagpoles, they may not restrict, or they may only restrict commercial messages. So with regard to the content, the only thing they're allowed to restrict is commercial messages, and they must be sure that any relevant rules associated with the display of flags do not prohibit or regulate based on a subjective matter regarding message or content. In substantially similar fashion to the amendment that we just discussed in subsection 1A, this year the General Assembly also amended the rules regarding signage in an HOA, which brings us to subsection 1C. Nearly every aspect of this rule is identical to the rules regarding flags. So can't ban them, but you may adopt reasonable content neutral rules regarding the number, the size, location, and so forth. But there is one small but potentially important difference. So in contrast to the rule regarding flags, which states that an association may not prohibit the display of a flag on a unit owner's property, in a window of the unit, or a balcony adjoining the unit, the rule regarding signage states that an association may not prohibit the display of a sign on property within the boundaries of a unit or in a window of a unit. And although the differences may seem semantic, it really is too soon to know how the courts will treat disputes that arise out of the difference in that language. So something to consider. In June of last year, House Bill 20-1200 was signed into law, and this bill amended Kiowa and was incorporated into section 106.5 subsection C.5, which includes protections for homeowners who wish to display religious items or symbols on the entry door or entry door frame of their unit. An association is not allowed to prohibit the display of a religious item or symbol if it is on the entry door or entry door frame of a unit. And this means that with some exception, you may display any item or symbol on the entry door or entry door frame of your home because of a sincerely held religious belief. However, an association is allowed to prohibit the display of items or symbols under certain circumstances. So for example, if the item or symbol hinders the opening or closing of an entry door, it may be prohibited, or one that contains language that is obscene or otherwise illegal may be prohibited. And an association may also regulate the size of the area covered by the items or symbols, which is statutorily limited to no greater than 36 square inches. With regard to this section, keep in mind the only information we're provided with regard to religious symbol or item is if it is because of a sincerely held religious belief. So if your association is going to challenge that, The best method to do that is through litigation. I would caution any homeowners association board to try and question a sincerely held religious belief just because. I think that is something that probably you should contact your attorney and explore your rights in civil court if you think that that is being abused. So the ability to park emergency vehicles by bona fide employees of emergency providers is another protection afforded by Kiowa. So long as certain criteria exists, an association may not prohibit the parking of emergency vehicles in an appropriate place within the association. Now, the resident must be a bona fide member of an emergency service provider, such as a fire department or law enforcement agency. And as a condition of their employment, the resident must be required to have the vehicle available at specified times at their residence. It must weigh 10,000 pounds or less and bear a visible official emblem of the emergency service provider, and it may not obstruct emergency access or interfere with the reasonable needs of other association residents. One hypothetical example of how these seemingly straightforward rules may produce a dispute is the fact that in Colorado, there are several private ambulance services. So would drivers of these vehicles fall under this rule? If the question led to a dispute within an HOA, the matter would need to be settled either via alternative dispute resolution, such as mediation or arbitration, or if that is unsuccessful or the parties are unwilling to engage in alternative dispute resolution, which is a voluntary process, then as a last resort, the issue would need to be litigated in civil court. Here in Colorado, fire safety and prevention is a very important issue. So much so that lawmakers have created protections for homeowners in HOAs when it comes to the creation of defensible space. For nearly a decade now, this section has been part of Kiowa. In short, it allows for the creation of defensible space, and an association must allow unit owners to clear vegetation if they are following a written defensible space plan. But keep in mind, this plan must be created under specific circumstances, either by the Colorado State Forest Service, an individual or company that is certified by a local government entity that allows them to create such a plan under that certification, or the fire chief, the fire marshal, or fire protection district for the jurisdiction where the association is located. So as board members, if you question anyone's defensible plan, you just want to make sure that it follows these guidelines. And if it doesn't, great best practice would be to go back to that homeowner and simply remind them of where the defensive plan must come from. You might even want to organize with your other board members a referral sheet that you can give out to folks so that they know exactly who they need to contact under these circumstances. This next section of Kiowa reiterates the requirements that housing providers have under the Fair Housing Act. Now, that's a federal law. Section 106.51G of Kiowa reiterates these by basically preventing an association from prohibiting the reasonable modification of a unit or a common element at the request of a disabled resident. So as long as the requested modification is necessary to afford the disabled person full use and enjoyment of the premises, and the requesting party is responsible for the costs associated with the modification, an association may not deny the request. The Colorado Civil Rights Division here at DORA enforces the Colorado Anti-Discrimination Act, also known as CADA, and that statute contains requirements that are substantially similar to the Fair Housing Act. So without providing legal advice, I would encourage board members, if you do receive a request for a reasonable modification, you certainly can discuss the request in terms of if it affords a disabled person full use and enjoyment of the premises. What I would encourage you not to do is try and litigate that within the association, meaning if you have any serious doubts as to the person's request, the result of being able to full use and enjoy the premises, contact an attorney and go through them and make sure that the concern is addressed appropriately. One thing that is going to likely lead to more disputes is trying to litigate that on the association level within the association without, when I say litigate, I mean, argue with somebody who's requesting that and force them to provide some sort of evidence of that full use and enjoyment. That really should be done through an attorney if you're going to question it. So since affordable housing is an issue in some areas of the state, lawmakers have incorporated certain protections for homeowners who would like to use their units to assist in providing more accessible housing. So in 2009, the Colorado General Assembly passed a bill that was subsequently incorporated into Section 106.5, Subsection 1H, which states that associations are prohibited from preventing homeowners from restricting the sales price, rental rate, or lease rate of their unit, or preventing them from creating occupancy or other requirements designed to promote affordable or workforce housing. It's very important to note that these protections only exist in associations located in counties with populations of 100,000 people or less, and that county contains a ski lift licensed by the Passenger Tramway Safety Board. Additionally, these protections do not exist in communities that are still under declarant control. Not too many best practices here, a pretty straightforward rule. If you have any questions about the implications here, I would strongly encourage you to reach out to your association's counsel. When it comes to restricting deeds, there are a lot of nuances. So if you see something and you think it doesn't quite meet this rule, please be sure to check with your attorney. So right after flags and signs, protections concerning ground covering are probably the most frequently asked about when homeowners reach out to the HOA Information and Resource Center. Subsection 1I prevents an association from prohibiting homeowners from using xeriscape, non-vegetative turf grass, or drought-tolerant vegetative landscapes when providing ground cover for property that they own or they are responsible for, as well as limited common elements. However, similar to some other rules we've talked about, associations may adopt and enforce design or aesthetic guidelines or rules that apply to non-vegetative turf grass and drought-tolerant vegetative landscapes, or regulate the type, number, and placement of ground coverings. This includes an association's ability to specify what type of drought-tolerant plantings and hardscapes may be used. Importantly, an association may also restrict the installation of non-vegetative turf grass, also known as artificial turf, to rear yard locations only. Something that many association members are unaware of is an association's inability to prevent the operation of a family child care home within an HOA. This is seemingly contrary to the general ability that HOAs have to prohibit commercial activity. A family child care home is statutorily defined as a facility for child care in a place of residence of a family or person for the purposes of providing less than 24-hour care for children under the age of 18 who are not related to the head of such a home. And while this section of Kiowa prevents an HOA from prohibiting a family child care home, it may still regulate issues of concern related to architectural control, parking, landscaping, and noise. Operators of a family child care facility located in an HOA may not park or instruct their clients to park wherever they'd like. They must obey all noise-related rules, and they may not landscape their property in a way that violates the association's governing documents. Now, one exception to this rule is that if an association has a rule regarding fencing that that may be incompatible with the operation of a child care facility, then the HOA must provide reasonable accommodation for fencing requirements applicable to licensed family child care homes. So one thing you might want to consider if you believe that your HOA may not have addressed this issue in your governing documents is to take a look at the state's requirements for licensed family child care homes in terms of fencing height requirements, and perhaps include some of that language in your governing documents, again, on advice of legal counsel. Importantly, this provision of Kiowa does not apply to a community qualified as housing for older persons under the Federal Housing for Older Persons Act of 1995, which is also known as a 55 and older community. So this next slide addresses an association's inability to effectively prohibit renewable energy devices and restrictions with regard to the requirement that homeowners use specific flammable roofing materials. We're going to talk more in depth about energy generation devices in the next few slides, and we are really seeing much less about cedar shakes and other flammable roofing materials being required by HOAs in recent times. So this slide is really just to close out the information provided in section 106.5 and to let you know of the issues and concerns that they address. In this next section of Kiowa, we are going to discuss 106.7, which, among other things, defines what energy efficiency measures are. Generally, an energy efficiency measure is a device or structure that reduces the amount of energy derived from fossil fuels that is consumed by a residence or business located on the real property. And for the purposes of the protections provided by Kiowa, this definition is limited to an awning, shutter, trellis, ramada, or other shade structure that is marketed for the purposes of reducing energy consumption. So what this means is that during the approval process, an HOA may ask the homeowner for evidence that the specific awning, shutter, trellis, ramada, or other shade structure was both purchased because and was marketed as a product that specifically reduces energy consumption. That's something important to remember. Additionally, this definition is further limited to a garage or attic fan, any associated vents or laveurs. And for those of you who may be unfamiliar, because I was and had to Google it, a laveur is a window, blind, or shade with horizontal slats that are angled to admit light and air, but keep out rain and direct sunshine. The definition of energy efficiency measures is further limited to an evaporative cooler, an energy efficient outdoor lighting device, including without limitation, a lighting fixture containing a coiled or straight fluorescent bulb and any other solar recharging panel, motion detector, or other equipment connected to the lighting device. That's a pretty big sub-definition there. This definition is also limited to a heat pump and a retractable clothing line. Note that the statute is very clear here. Any clothesline that is to enjoy the protections of this section must be one that is retractable. We get a lot of inquiries about this one because many homeowners are under the assumption that any clothesline must be allowed. And that is unfortunately not the case. The statute is very specific, and it must be one that retracts. And as with many other provisions that we've discussed today, the association may still impose reasonable aesthetic provisions that govern the dimensions, the placement, or the external appearance of an energy efficiency measure. And while Kiowa does not define reasonable for us in this context, it does go on to provide some guidance to boards in creating those aesthetic provisions. And when doing so, a board should consider the impact of any aesthetic provision on the purchase price and operating costs of the energy efficiency measure, the impact of any aesthetic provisions on the performance of the energy efficient measure, the criteria contained in the governing documents of the common interest community. And in addition to reasonable aesthetic provisions, this section also does not apply to bona fide safety requirements, which are consistent with applicable building code or recognized safety standard for protections of persons or property. So any county code or any municipal code that may be counter to the allowance of these devices will take precedence under those circumstances. Keep that in mind. So the next and final section of Kiowa we are going to discuss this morning is section 106.8, which discusses unreasonable restrictions on electric vehicle charging systems. This section, an association may not prevent a unit owner from installing certain electrical vehicle charging systems on or in their own unit, nor may an association charge any fee for doing so. However, the installation must be at the owner's personal expense and for the owner's personal use. Additionally, an association may require reimbursement for the actual cost of electricity provided by the association that was used by the charging system, or alternatively, may charge a reasonable fee for access. Now, keep in mind, this is in regard to a charging system on or in an owner's own unit. Again, with many other of the provisions that we discussed today, the association may still impose reasonable aesthetic provisions, and they may govern the dimensions, the placement, or external appearance of an electric vehicle charging system. You can't have one out there that looks like a clown if your association tells you you can't. Additionally, an association may require that the unit owner register the charging system with the association within 30 days of installing it. And similar to the discussion on energy efficient measures, this section does not apply to bona fide safety requirements. So again, if your municipality or your city or locality has any restrictions that would vitiate some of these protections, they are going to take precedent. And finally, if a unit owner will be installing an electrical vehicle charging system in or on their own unit, then the processes and protections are much more simple than if the unit owner is trying to install such a system on or in a limited common parking space, carport, or a garage owned by the unit owner or otherwise assigned to the unit owner. And while I am not certain, and you should certainly check with an attorney who's well versed in this area of the law, I believe that the reference to garage in this section is communal garages. A lot of time you see them in condos where there's rows of garages. I do not believe that this portion of the provision is with regard to garages that are attached to a single family home. However, if you do have any dispute within your neighborhood regarding that discrepancy, please do contact a qualified community association attorney. So there is far too much detail to go into during this presentation with regard to the installation of a charging system on or in a limited common parking space, carport, or garage. But suffice it to say that the process involves an agreement between the unit owner who wants to do that installation and the association, and it must address a variety of issues, all of which must be worked out prior to the installation. So something to keep in mind if these circumstances are relevant to your circumstances. All right, let's talk some best practices here. So there are definitely some best practices we can talk about when it comes to unreasonable restrictions and prohibitions contrary to public policy in HOAs. And these can generally be applied to most of the issues we've talked about today. For associations, you want to be sure to review and update your association's governing documents as necessary. Let's see, so some HOAs have been aware of the new flag and signage rules which did go into effect early September of this year. They may have been aware of them for quite some time and have already consulted with their association's legal counsel and drafted some new, more appropriate guidelines, while others may be hearing about it for the first time today. So once you've reviewed your governing documents, be sure to follow them. Hypothetical here, let's say a board member notices that their neighbor has 11 signs in their front yard, but the association's reasonable, content-neutral rules limit the number of signs to 10 signs per unit. The board member should follow their association's covenant enforcement policy, which likely calls for a formal notice with a written request to the homeowner that they cure the violation within a reasonable amount of time. But what if the board member is good friends with this neighbor? Well, they may be tempted to informally let them know about the rule and just suggest they take down a sign. Now, I know there's going to be some disagreement about this. Many people may view this as a reasonable and neighborly thing to do. However, it is these types of niceties that end up creating animosity in communities and fuel arguments from other members of the community who may not have been extended such courtesies. So under that hypothetical we talked about, a more appropriate way for the board member in our story to have handled this situation would have been for them to let their neighbor know of the rule, suggest that they remove a sign, but also let them know that the association will be sending them a friendly reminder notice about it, just so that there is transparency in the community. This way, the issue is documented, the board member follows their covenant enforcement policy, and there is no inequity in the treatment of homeowners. Finally, associations must remember that they may not fine any unit owner for any alleged violation unless the association has adopted and follows a written policy governing the imposition of fines, and the policy includes a fair and impartial fact-finding process concerning whether the alleged violation actually occurred, and whether the unit owner is the one who should be held responsible for that violation. This process may be informal, but it must, at minimum, guarantee the unit owner notice and an opportunity to be heard before an impartial decision maker. And while Section 209.5, which I'm referencing now, goes into greater detail regarding the definition of an impartial decision maker, note that under most circumstances, it will be appropriate for the board to act as that impartial decision maker. With regard to best practices for homeowners, some of the same best practices apply. Before you decide to raise a flag or post a sign, read the relevant sections of your governing documents. Don't ever assume that because an association hasn't sent out a specific notice regarding flags or signs, that they don't have rules regarding them. Also, make sure that you determine the necessity of submitting an approval request to your board before raising any flags or signs, or doing anything else that we talked about today. Just because there is a protection in Kiowa for it does not mean that they must allow every single flag or sign or energy efficient measure, because they don't. Remember, they still may adopt reasonable, content neutral rules regarding the number, location, and size of flags, flag poles, and they may require prior permission to displaying them. And again, the same goes for energy efficient measures. Even childcare facilities should talk with their association